Good morning, everyone, and welcome to the second installment of Fasken's Estate Litigation webinar series, How to Ensure Your Estate is Squandered by Litigation. Previously, Alex Kotkis, Lily McLeod, and Janice Coe gave an informative webinar on substitute decision makers and handwritten wills. If you weren't able to tune into that webinar, or if that topic sounds like something you'd be interested in hearing more about, we will include a link to those materials following this presentation if you want to review that. My name is Desmond Mitic, and I'm a Litigation and Dispute Resolution Associate in Fasken's Calgary office. I'll be facilitating our discussion this morning. Joining me are two of Fasken's estate litigators who will share some of their experiences, insights, and expertise with us. From Quebec, we're joined by Yoni Feingold. Yoni is a partner in the Litigation and Dispute Resolution Group in our Montreal office, where he routinely resolves disputes in the areas of wills, trusts, and estates, in addition to general commercial litigation matters. From British Columbia, we're joined by Eric Clavier. Eric is a partner in the group over there, where he specializes in trusts, wills, and estates litigation. Over the next hour, Yoni and Eric will share some of their experiences with us to help us understand just how easily estate matters can end up embroiled in litigation and how to maximize the value of those estates should that occur. For those of you who have submitted questions to our panelists in advance of the webinar, we thank you. We'll raise those questions with the panel throughout the course of the discussion. For those of you who have not submitted questions, but may have questions as the discussion unfolds, I encourage you to drop them into the chat feature in Zoom in real time. We'll endeavor to address all of those questions by way of follow-up if necessary. With those introductory remarks out of the way, let's turn to the panelists for a moment. Eric, how are you this morning?
I'm very well, thank you, Desmond.
Great, thank you for being here with us this morning.
It's a pleasure.
Yoni, how are you?
I'm good too, thank you. Thank you for the introduction, and thank you everybody at home or at your respective offices for joining us today. Looking forward to this discussion today with you.
As am I, Yoni. Perhaps you could get us started by giving us a little bit of insight into your practice area and how you find yourself encountering estate litigations.
If you're starting with me, happy to begin. So as you mentioned, I'm a partner in the litigation section at Fasken in Montreal, in the Montreal office. My focus is on estate and trust and incapacity issue litigation. We have prepared and will be discussing a number of very interesting topics. And like you mentioned, without proper planning, you can find yourself or you can imagine your estate embroiled in very costly litigation very quickly, which can be avoided by just simply speaking with the appropriate advisors and seeking legal counsel.
Yes, we do see it time and time again. Eric, let's go to you for a second. Can you give us a little bit of background on your practice and how you have been dealing with estate matters throughout it?
Sure, and so I pretty much do the same thing that Yoni does. I only litigate, and I litigate in the trusts, estates, and incapacity space, as well as also charitable litigation arising from trusts or from wills. And I've found over the course of practice in this area that it's becoming ever more prevalent. A lot of people are taking part in a massive transfer of wealth from the baby boomers to the next generation. And it's just going to get more and more prevalent that you're going to see litigation arising where there are disgruntled beneficiaries, there are disgruntled family members. It's kind of sad, actually, to be honest, because it'll often result in fracturing of the relationships between siblings or between spouses and stepchildren, for example, but it is a reality. And so what we are aiming to do here today is to point out some of the mistakes we've seen, some of the things that can result in almost inevitable litigation. We're going to try and give you some tips as to how you can avoid those, but obviously it's such a broad spectrum of information, we can't cover it all. We just cherry-picked some of the edited highlights and some of the most common mistakes that we've seen in practice, and certainly that I can relate to from having been involved on both sides of files with respect to all of these issues.
Thank you, Eric. And I agree. Ideally, these estate litigations could be avoided, but in many cases, they are an inevitability based on how the plan has been set up. So with that, and to start off our discussion, why don't you let me know what you think the biggest mistake people make with respect to their estate plans is that leads or can lead to litigation?
Okay, well, let me take that one. The worst mistake you can make is not to have an estate plan at all. I mean, that goes without saying. No plan is not a good plan. So at a bare minimum, you should be looking at having a will in place, a power of attorney, or a healthcare representation agreement. I appreciate that in different provinces across the country, those last two may have different names. And while those three tools aren't necessarily appropriate for every specific estate that's very fact specific, they are still better than the alternative of not having a plan at all. Without a plan, there will be rules of intestacy that decide how your estate is distributed amongst your heirs. There's nobody that you've appointed that you trust to administer your estate and your assets upon your death. And so the court will have to follow a hierarchy of potential estate administrators. And that inevitably is going to lead to a battle between family members about who should be appointed. And you have no control anymore. You've passed away. It's a question of, would the person in the hierarchy be someone that you trust? Are they up to the challenge? And is it going to result in a battle essentially between the hierarchical descendants of your estate as to who should actually be the one to be impressed with this fiduciary role of administering an estate for which they are a trustee? So having no plan is no plan at all. We accept that for today's discussion purposes, though the audience knows that. We're going to focus more on common litigation triggering planning mistakes, which people make. And so we're not going to focus on not having a plan. We're not going to give you a planning lecture or a discussion on how to avoid any form of risk. Well, we're going to point out how you are going to see risk materialize unless you make certain steps or take certain steps to prevent them.
Thank you, Eric, and you're quite right. I think most people do have a plan, and what will be interesting for the purposes of this discussion will be to hear about how even with a plan in place, we can see litigations crop up that were not necessarily foreseen and, in our view, could have been avoided. And I think a lot of the time we encounter clients who are doing things during their life in the course of making their plan, like gifting property, whether it be, for a planning purpose or otherwise, without necessarily appreciating all the risks that doing so can entail. So I know you encounter these quite a lot, Eric. Can you explain to us a little bit about what these risks are about inter vivos transfers of property during the testator's lifetime that might or can lead to litigations?
Sure. And so what you're speaking about is where someone will make a gift, an adult, for example, will make a gift to one of their children during their lifetime by putting them on a joint title, for example, for the property that they own. Alternatively, they put them on joint title of a property in order to help administer that property. And then they're expecting that the right of survivorship will trigger upon their death, and the child will receive the property without it having to pass through probate, without there having to be a will. So that is an estate plan that you can have. It is certainly something that many banks will recommend, is to have joint bank accounts between parents and their children, to have property put on joint title. But the problem with that kind of estate plan is that if it's not properly papered, if it's not properly documented, you're running into a brick wall called the presumption of resulting trust. And essentially, that is a near inevitability when it comes to a lack of proper documentation with respect to a gift. Either a gift made outright at the time of you being still alive, in other words, an inter vivos gift, or by making an outright gift of joint tenancy with the right of survivorship to be taken upon your death. So the reason why this is a risky planning tool, albeit that it is one, is because in common law Canada, at least, gratuitous transfers are subject to this presumption of resulting trust. Now, what is a presumption and what is a presumption of resulting trust? in its barest form, a presumption is a fact that is presumed to be true under the law. And so a presumption, in this case, the presumption of resulting trust, is a factual inference that has been standardized by the law into a prima facie conclusion. I'll give you an example. If X, dad, transfers property, which is fact A, to Y, fact B, the son, for example, the court will presume that he does not intend to do so beneficially, the inference being fact C. Or put differently, that dad, X, only intends to transfer legal title to the property to Y, the son, not the equitable interest, which X retains for himself. And so this is the presumption of resulting trust. Essentially, if there is a transfer of an asset, and it can be a bank account, it can be real property, it can be bank shares, it can be shares in the stock market, whatever the case may be. If you're transferring an asset from an adult to another adult, there is a rebuttable presumption that you intend only to transfer legal title and to preserve for yourself equitable title. In other words, the actual right to use that property, to use that asset for yourself. Now, that's a prima facie conclusion only. It's rebuttable on the evidence, but you would need to, as the person asserting that you were actually given a gift, as opposed to holding this asset in trust for the transferor, you would have to present evidence, which is why I started off by saying you need to have a proper paper trail in place. If you want to make a gift, you need to put in place a deed of gift. You need to make it crystal clear that your intention was to gift your legal and beneficial interest to the recipient of the transfer, because if you do not do so, the court will presume the resulting trust. How does it operate in practice? Well, it occurs where there is a purchase of property in the name of another person or a voluntary transfer of property. And so you can have this purchase money resulting trust, which is the first of the two, or a gratuitous transfer resulting trust. And the second component is that there is no clear evidence concerning the actual intention of the payer or transferor about who is intended to benefit from the transfer. So very basic examples. I've used the example of dad transferring a property to his son, but what also happens in practice is someone will, at the advice of an estate planner or at the advice of their bank, put their child on a joint bank account, with the intention being that they're going to assist them in the administration of their financial affairs. Maybe mom or dad is in decline. The law presumes that that joint tenancy is in trust for the parent. And therefore, even though the right of survivorship will be triggered at the time of death, meaning that the bank account then becomes entirely held by the child, the court will presume that that child holds that bank account and the funds in the bank account on a resulting trust for the deceased's estate. That will lead to litigation. Why? Because disgruntled family members will inevitably feel that mom or dad, or whoever the case may be, benefited their siblings to the exclusion of themselves, and they will rely on this presumption of resulting trust to make a claim in order to try and recover for the estate an asset which then will be divided between the beneficiaries of the estate. It is almost near certain that unless that child that received the bank account or that received the property is able to produce documents to prove that that was mom or dad's intention, that that matter is going to end up in court. It's going to end up being expensive. It's going to be a delay. I'll give you an example from a case of mine. Mom and dad didn't have an estate plan. They had no wills in place. Their intention was to put all of their properties, of which there were many, and they were very valuable because we're talking about British Columbia property, of which there were many, they put those in joint tenancy with each of their 5 children. And what happened is one of the children then got divorced, so they removed him from joint title. The intention always was to try and minimize tax and probate fees. So at the time of mom's death in 2005, there were 4 of the 5 siblings that had properties under their name in joint tenancy with mom, and those properties then passed from mom and this child to just the child holding it alone. In 2010, dad died also without a will. He'd also been on joint title with some of the children, with the exception of this one child. And so everything that had been held in joint tenancy by dad and the children moved on to the children by right of survivorship. So now you had a situation where you had a bunch of properties held by the children of mom and dad. They were no longer around. They had papered nothing. And almost inevitably and as predictably, we would have seen in most cases in this kind of scenario, there was a lawsuit that followed. There was a dispute about who the administrator should be, as I mentioned earlier on. Once an administrator that was a trust company was appointed, the administrator commenced a claim on resulting trust, calling upon the beneficiaries to show that they in fact had received gratuitous transfers. So just by way of background again, 2005, mom died, 2010, dad died. The case is still not resolved. There is a settlement which almost finalized the matter, but neither mom's estate nor dad's estate has been finalized. And the legal costs to date are probably about $2 million across the board, with most of the family now in camps hating each other. So the takeaway from that case is resulting trust claims are real. They happen before you know it, and they're easy to file because the person going to court armed with the presumption of resulting trust is calling on the other party to produce evidence, which in the absence of which they are unable to prove a gift, and the asset will essentially go back into the estate of the deceased person, which may not be what mom or dad had intended.
Thank you, Eric. And it's interesting, the presumption of resulting trust is certainly something people need to be aware of. As you've mentioned, it can crop up all the time. And, even with individuals or estates where they think they have a plan in place or they think they've devised a strategy that's going to be useful for them in the future, and it could lead to a messy litigation. Let's talk to you a bit, Yoni. Are these presumptions something that are applying in your jurisdiction? Are you seeing these types of claims in your practice?
So perhaps I'll state the obvious at the outset. The rules are not uniform across all jurisdictions and across all the provinces. My contribution will really be focused on how things play out here in Quebec, which occasionally are very similar, but frequently very different. So fortunately, we don't encounter the same issues, and the reason is rather simple. If you want to make a valid inter vivos gift, you have to respect very strict formalities. In particular, the gifts have to be done by a notarial deed. So if you want to gift property, or if you want to gift even significant asset, an amount of money, etc., that gift has to be notarized and prepared in writing by notarial deed. So we can't, it will not happen that there is a question after the fact as to whether or not the gift was made. If it's not done that way, it's deemed to be absolutely null. There are some exceptions to that rule. If an individual, a parent or a friend wants to gift some property of small value or anything that can literally be handed over, where the person dispossesses themselves of the asset and the person benefiting from the gift can take it and walk away and has possession of it, that need not be notarized, but otherwise it's done by notarial deed. So the presumption of a resulting trust is not something we encounter in my jurisdiction. That being said, courts do have on occasion read a trust, or essentially find a trust within a will, even where the language of the will is rather plain and there's no reference whatsoever to the creation of a trust. That is frequently done for equitable reasons, and I can give you an example from a recent decision where the testator intended to leave or benefit charitable organizations with a reasonably sizable estate. And I'll read the clause in the will in French, and then I'll translate and we'll look at it. So the testator states, Je désire que la valeur de l'ensemble de mes biens aille à des œuvres de charité qui seront choisies par mes héritiers. Mon liquidateur paiera ces organismes choisis. So basically saying, I intend to leave the entire value of my estate to charitable organizations which will be chosen by my heirs, and my liquidator will pay these organizations. Now, the trouble is that under Quebec law, a testator cannot delegate the power to name a beneficiary to a liquidator or to an heir or to a third party. There's no power to appoint, as we call it, that can be given to a third party under a will. That can only be done in the structure of a trust or or within the framework of a trust. So what the court did in this particular case, and I believe it was done really in equity more than in the strict adherence to the law or application of the law, the court found that what the testator intended to do was create an autonomous patrimony where the testator's patrimony would be transferred. It would be for a specific purpose, which was to benefit the charitable organizations, and it would be administered by the liquidator or the executor. So those are the types of trusts that can be presumed. Very different, of course, in what Eric was discussing, but I figured that I would add my 2 cents and 2 cents of a province.
Appreciate that, Yoni. And a very interesting case where, I think a bit of action from the bench occurring in somebody's estate plan is always a bit surprising. And I'm just noting that a couple of questions are rolling in with respect to the presumption of the resulting trust that you were explaining, Eric, and I think now would be a good time to address them. You mentioned that the presumption is rebuttable, and we have quite a few questions coming in. Maybe you could just speak to, what kind of evidence you would normally use or you've seen used to rebut that presumption, and in particular, if it's a family situation and one sibling is getting a gift, would consent by the other siblings be good enough evidence to rebut the presumption?
Okay, so the first question is what evidence would rebut the presumption? And that's very fact and case specific, but the most obvious answer would be where you have a document prepared by the donor that evidences that they intended to make a gift. So that would be a deed of gift or a document evincing a gift of some sort being made from the donor to the recipient, being done with independent legal advice, being signed in the presence of a lawyer who can speak to the capacity of the adult making that transfer at the time that they made the gift, and who can speak to the fact that in their analysis or assessment anyway, there was no suggestion or hint of undue influence, right? So that would be the most obvious. But you could, if you're not able to persuade the other beneficiaries of the estate or your siblings that there was in fact a real gift, you could be looking at a lawsuit anyway. And in that lawsuit, you would be in all likelihood trying to produce or getting the solicitor's file, the planning file, the estate file of the solicitor who assisted mom or dad produced as evidence, because that's going to be telling. If there are notes on the file, they may speak to what was discussed by the parent with their solicitor when the transfer took place. The solicitor may tell the beneficiaries what happened. There might be an interview with the solicitor. You don't have to wait until a lawsuit is commenced. You could have all the beneficiaries of an estate meeting with a round table, for example, with the solicitor. If the executor is prepared to disclose the content of the solicitor's file, he could authorize the solicitor to release that, and that may be evidence that's satisfactory, but it really depends. And if you don't have that kind of evidence, you would be going to court potentially as the recipient saying, well, I'm going to call some evidence of family members who had discussions with mom or dad at the time that they were doing this, because mom and dad told them why they were doing it and what their plan was. And so, for example, it could be anything. If there is a memo, a note to self, or an email or something that someone wrote to themselves saying, hey, I should do this because it seems like a great idea and I really want to make a gift to person A because they've been there for me, then that would be evidence that can be admitted as well. But you do have to understand that it has to be good evidence, and it has to be enough to rebut the presumption of resulting trust. One thing that I will say, and I don't want to do a doctoral thesis on resulting trust, but I'd say this, is that the court will only rely on the presumption if it cannot make a finding on the evidence. So in as much as the presumption triggers the lawsuit, if there is a finding that the court can make on the facts, the presumption becomes irrelevant. If the court is unable to determine whether or not mom or dad intended to make a gift and the possibilities are level, then the presumption trumps the gift, and it will revert back into the estate. And so basically what happens is that the presumption then is that the gift was in fact not a gift, but that there was a transfer with a trust, and that the trustee of that trust, being the recipient of the title, is holding that asset on a resulting trust for the estate. Therefore, it's an estate asset. Probate fees are going to have to be paid on the property, and it's going to be distributed as part of the estate, however the will sets out the distribution scheme.
Thank you for that, Eric. Very interesting. And, as you state, obviously a deed of gift is the way to go, but in cases where one doesn't exist, the calling of evidence and the weighing of that evidence is going to have to happen. And that's going to sometimes drag on for many years. But now let's turn to another topic that we see come up time and time again, and that's challenges to a formal will document after the testator has passed. A lot of the times, these kind of challenges are focusing on or circulating around events that happened in and around the time of the testator's passing, such as changes to wills, the execution of new or updated wills, and these kind of things. So we see these situations often are going to spawn opportunistic litigations. So let's go to you, Yoni. Maybe you could tell us a little bit about how some other legal presumptions apply to wills that were made late in a testator's life or to buried wills, and how they tend to expose an estate to litigation.
Sure. Well, perhaps I'll start by saying that yes, these are some of the main challenges to wills and some of the most costly types of litigation that we see in estate litigation. Costly in terms of fees, costly in terms of the lawyer's fees, but also experts' fees, because questions of capacity require medical expert, and costly because it takes a tremendous amount of time to ultimately litigate and adjudicate. With respect to presumptions, we can discuss the first one being that capacity is presumed under the law, and if a relative, a sibling, a descendant, a child is alleging incapacity, the burden falls on them to make the proof of incapacity. However, under the law, once that allegation is made and proven on a prima facie basis, then the burden of proof shifts once again to the party trying to confirm that the testator had the necessary capacity to testate. But practically speaking, and regardless of how those burdens play out or are treated by the court, as soon as there is a serious allegation of incapacity, all parties are running to medical experts to prepare detailed reports on the cognitive or neurological condition of the testator at the time that that testator prepared the will. That's key as well. With respect to the undue influence, there are legacies that are deemed to be invalid as well. So they're not presumptions in law, but they're strictly stated as invalid legacies. And I would say that at the heart of those rules is the concern that were it not for them being deemed to be invalid, vulnerable testators would potentially be exploited in situations of dependence. So I could give you a list as they appear in the civil code. So for instance, a legacy made to a notary, the spouse of the notary, or a relative of a notary in the first degree would be deemed to be invalid. Legacy made to a witness would be deemed to be invalid. Here's an interesting one at Article 761. It states, a legacy made to the owner, a director, or an employee of a health or social services establishment who's neither the spouse nor a close relative of the testator is without effect if it was made while the testator was receiving care or services at the establishment. So clearly what we're seeing here is a concern that a vulnerable individual be influenced by someone upon whom they are dependent to testate in their favor, to leave something to them as a result of their dependence. So those would be the main presumptions here in Quebec.
Thank you, Yoni. And I find myself wondering as you're reading those points of the civil code to us, if there is an air of undue influence around a particular testamentary document, is this a simple fix, to prove that the testator was not acting with undue influence? Is it something that is going to be, a quick court application, or do these matters tend to drag on? Maybe you could explain to us some of the specific examples you've encountered in your practice and what the lifespan of those litigations look like.
Sure. So generally speaking, cases that deal with undue influence, where the main allegation is undue influence, are harder to prove than cases that are purely based on incapacity. Incapacity will turn on a medical report and medical evidence, and experts will come and the court will really rely on that. Undue influence and classic cases are, for example, testator leaves everything to a second or third spouse and disinherits the children from a previous marriage, and the children consider that to have been unjust, or certainly the doing of the second or third or subsequent spouse, or a case where a resentful sibling has been disinherited and points to one of the other siblings for having brought about or unduly influenced their parent. So they're harder to make, or the undue influence is harder to prove. It's very highly fact-driven, and most of the facts and evidence have occurred behind closed doors. So if you're going to be influencing a father or a spouse to disinherit somebody or to benefit you to the exclusion of others, you're not going to be doing this out in the open. So it's very hard to actually find, good witnesses who will come forward and be able to demonstrate through testimony that, yes, I heard so-and-so constantly speaking poorly of the other, and proving that the testator had been influenced. Another issue is that the cornerstone of our system here in Quebec is the freedom to testate. So the court is supposed to take that for granted, that a testator is free to leave their estate and dispose of their assets however they so choose. There isn't a presumption, and there shouldn't be a presumption, that a parent will naturally leave their estate to their children, or that a spouse will leave the estate to their spouse. So that's one of the factors. I think it might be useful, in fact, to define undue influence as it's been understood by the courts. I could read one from a recent Court of Appeal confirmed decision. Undue influence connotes fraudulent efforts by a legatee that convince a testator to make bequests that he or she would not otherwise have made. The party who alleges undue influence thus has to prove, on a balance of probabilities, that the accused party is guilty of improper schemes, disgraceful devices, lies, slander, deceit, and trickery, or deliberate misrepresentations, usually accompanied by systematic denigration of other contenders for the estate. So that is a pretty high burden. That's a high threshold to meet. And we don't frequently see successful challenges on the basis of undue influence. The final point with respect to the process is that it's very difficult to appeal. And again, that has to do with the fact that it is so highly fact-driven. The appellate courts are highly deferential to first instance judges when it comes to the appreciation of evidence and facts.
Thank you, Yoni. Those are some helpful insights. And I take your point that there's a lot of evidence that you need to successfully bring an undue influence claim. And indeed, a lot of that evidence isn't very easy to find, just simply by the nature of that type of situation that would lead to the necessity of bringing an undue influence claim. But Eric, I want to hear a bit from you about the challenges you see to wills, and what the process looks like in the common law provinces like British Columbia there. And in particular, we have it written on the slide here, the requirement of proof of will in solemn form. Maybe you could tell us what that's about and when you encounter it.
Sure. And so I find it interesting because there's certainly a lot of overlap between what Yoni says the situation is in the civil law jurisdictions such as Quebec and the common law jurisdictions. We've also got several presumptions, as I've mentioned earlier on. A fact assumed to be true under the law is called a presumption. It's always rebuttable by evidence, right? But there's a couple that we have that they have in the Quebec system as well. The first is that adults are presumed at law to be capable until the contrary is shown. So unless you're able to actually provide evidence that suggests that the person who made a will was incapable of forming an informed decision about their estate and how it should be divided, that adult will be presumed at law to be capable. So where there are challenges, those challenges will usually be on the basis of incapacity, to try and rebut this presumption, because as Yoni mentioned, undue influence is a hard nut to crack. And the same thing is true in common law Canada. I'll get to it a little bit more, but I'll just say that generally speaking, challenges against wills are made on the basis that the deceased lacked capacity or understanding of what the will was. And then as an alternate or as an afterthought, sometimes there'll be a claim for undue influence. But what you have when you run into this presumption of capacity is you run into a second presumption with respect to a will. And that is that if a will was duly executed in accordance with the requisite statutory formalities, after it was read over to the testator or by the testator who appeared to understand it, it is presumed that the testator possessed the requisite testamentary capacity and in fact knew and approved of the will's contents. And that presumption can be rebutted by evidence of well-grounded suspicions, which are suspicious circumstances in our jurisprudence, which may arise from circumstances surrounding the preparation of the will that tend to call into question the capacity of the will maker or tend to show that the free will of the will maker was overborne by acts of coercion or fraud. So there is the presumption, unless you're able to show these suspicious circumstances, that provided the requirements were met, statutory formalities, and it was read over by the will maker, he's presumed or she's presumed to have known what they were doing and to have had capacity. The third presumption that is in play when it comes to these kinds of challenges is a presumption of influence in a relationship of dependence. And that is something which doesn't just apply with respect to wills, but it applies to inter vivos transactions as well. And so the courts impose a presumption of undue influence if there is a potential for dependency or domination between the will maker or the gift maker and the recipient of a gift. In the case of a will, a testamentary gift. In the case of an inter vivos transfer, an ordinary gift. And so, in other words, what the court requires is that once a relationship has been demonstrated that has the potential for domination or dependence, then the person alleging the gift, the recipient of the gift, has to rebut the presumption on a balance of probabilities and would have to show that the donor entered into the impugned transaction or made the will of his, quote, full, free, and informed thought. End quote. So those are three presumptions that you automatically are dealing with when you're dealing with disputes regarding wills. As I mentioned, there are three basic ways of challenging a will. The first is lack of knowledge and understanding, lack of capacity, although those two usually go hand in glove, and then undue influence. But undue influence, as Yoni alluded to, is a serious allegation. The courts treat that as serious. So if you're going to go and make an allegation that someone is unduly influencing a will maker or unduly influenced a will maker or a gift maker, you need to know that you're accusing that person of something akin to fraud. And if you don't have the evidence to back it up, you're going to be looking a special costs order in the face, right? So that's how courts punish people who make scurrilous allegations of undue influence. But of course, they're aided by the presumption of influence in a relationship of dependence. And that relationship of dependence, the most obvious would be where you have a care provider, someone who is providing 24/7 care to the will maker, suddenly has left a huge amount of money in the will maker's estate. Well, there's a presumption that the deceased was under the influence or was dependent on the care provider. The care provider could have threatened to withhold care and unless he's included in the will, right? So that's why that presumption assists the party challenging the will on the basis of undue influence. But of course, it can be rebutted on evidence by the recipient of the gift. But that would be one way in which the party who wasn't there, as Yoni says, because undue influence happens behind closed doors, how that person can get into court and force the recipient of the gift to essentially come and prove that they were in fact gifted something by an adult acting of full, free, and informed thought. Now, what happens when the will is disputed on any of these grounds? If someone disputes a will, then the executor named in the will must prove the will in solemn form. So there are two ways of proving a will. The first is proof in common form. That's when there's no dispute. That's when all that the administrator or the executor does is to show the court that the will was signed by the deceased in the presence of two witnesses who signed the will in the presence of each other and the will maker. And then the will be admitted into probate. That's the easy, it's the cheap, it's the quick, it's the efficient way of proving a will. Proof of will in solemn form of law is more complicated. In that case, the executor has to show that the will maker actually had capacity, that he was acting free from influence, that he or she knew what they were doing and read over the will, had understood it, and were in a position of making a valid testamentary instrument. And that's more challenging because you need to get the evidence of the person who assisted the will maker in making the will. You might have to get the witnesses who signed the will to come and confirm what their observations were. All of that runs up costs. All of that, in all likelihood, is going to result in challenges by other recipients under the will, because perhaps under this will, they're getting 20% of dad's estate, but there's a former will under which they're getting 40% of dad's estate. And so they want this will to be set aside on the basis of whatever grounds, undue influence or lack of capacity, because then we revert to the earlier will under which they get more. So you're looking at more likelihood of there being a challenge. It's a much higher cost, much more evidence needs to be obtained. It takes longer to assemble and put together, and it will in all likelihood deplete the estate significantly. I mentioned earlier on that it's not necessarily just that the challenges will be in the will's context. If someone, for example, settles a trust during their lifetime or creates an alter ego trust, you'd have the same challenges to those kinds of instruments that are available, such as lack of knowledge, lack of capacity, or undue influence. I'm currently involved in two files where that's exactly what has happened, and I'm on either side of this. And on the one, I'm defending an alter ego trust that was settled by someone who's still alive and is now being challenged by one of his daughters because she doesn't like the way that it deviates from what she receives in the will, and so wants to have the trust essentially dismantled so that the assets go back into dad's estate, and when he eventually dies, he's lost capacity. In the meantime, she'll get a larger share. The other one that I have is we've got a claim where we're trying to set aside a will because my client is an interstate heir of the deceased and received nothing from his brother in the will. So it's he and his sister and the brother were the sole surviving members of their family. The sister has some children. The brother recently passed away, created a will, and he left everything to the sister and her two sons. And so we have reason to suspect that there was a relation of dependence. We've pleaded it on that basis. We're trying to set aside the will on the basis of undue influence and the alternative that there was a lack of capacity. But again, it's already cost a fortune. We're not even at the stage where we've received a response to civil claim. There's going to have to be discovery. There's going to be document production. You're looking at a good year or two at least, and that's best case scenario, getting that matter done. In the meantime, the relationship between my client and his sister is now irreparably broken. So as far as a potential avoidance plan is concerned, because that's something that is, of course, on everyone's mind, is how do you avoid this? Well, tough to do. There are the presumptions that aid people who want to challenge things or who want to assert that they are true. But at the same time, if you're intending to make a will or settle a trust, the most important thing is for you to seek independent legal advice. You can certainly do it with a notary. There's nothing wrong with that. But going to see a lawyer who practices within the estate planning place is important because they will keep notes to file. They'll keep proper notes of what was discussed. They know what to look for when it comes to undue influence red flags. And so hopefully, if there is a challenge later down the road, they would be able to provide a compelling argument or compelling evidence as to why they believed that the will maker or trust settler had capacity, that they weren't acting under undue influence, and that they in fact knew what they were doing when they settled the will, settled the trust, or made the will.
Des, if I can jump in just on the last point on is avoidance possible, and if so, how? So what I would add to that is, when it comes to capacity, particularly if you're an older individual who wants to modify their will, or if you're really any age but you are dealing with a terminal illness and you're trying to take care of your estate, what I would highly recommend is obtain a medical assessment, either a neurological assessment or really an assessment by your GP, who is able to determine and confirm that you have the cognitive capacity necessary to testate. That can be documented and kept in your file with the will that you ultimately prepare. That's one. The second would be, if you're going to exercise your freedom to testate and do something perhaps unconventional, disinherit your children, leave everything to a spouse, or disinherit some children for the benefit of others because, for example, two of your children are extremely well off and don't require anything from your estate, but a third child has been struggling and you want to leave everything to them, and you don't want it to result in any meaningful litigation down the road that will squander your estate, you can prepare a letter precisely explaining the reasons why you have chosen to structure your estate a certain way. You can even discuss it in advance if it's clear. But certainly having an additional statement that seems to be produced independently of the person who would otherwise have influenced you to leave them the estate will weigh heavily in, should the estate ever be contested, but certainly avoid potential litigation, which, as we mentioned and Eric mentioned, is very costly. And in our jurisdiction too, just to touch upon another point Eric made, very frequently it's the same thing. Very frequently, an action is taken first on the basis of incapacity, and it's coupled with undue influence. So you're going to see the costs skyrocket here in Quebec in particular, because you're going to have experts come and weigh in on cognitive capacity. If I could do we have time for an example of a recent decision that on undue influence that really it helps illustrate the importance of either stating up front why you're doing something, or yes, do we, Desmond? Yeah. Okay. So,
please, Yoni. Thank you.
Okay. So, recent decision, again, it was confirmed, first instance judgment confirmed in appeal. I'll give you the facts very briefly. The testator decided to leave his estate to his wife of 20 years. She's a second wife of 20 years, not the biological mother of his daughter, his one daughter. The relationship that he had with his daughter was strained, but the proof showed it was still loving. It was a difficult relationship because the daughter suffered from bipolar disorder and made things complicated and challenging. The daughter's mother, biological mother, happened to be a wealthy woman, and in fact, there was a trust that had been set up to benefit the daughter. The daughter and the second wife, as you can imagine, given that this ended up in litigation, had a very acrimonious and strained, difficult relationship. And finally, the second wife was incredibly devoted and found to be incredibly devoted to the deceased, managed many aspects of both his personal and professional life. So those are the facts that were presented to the court. The daughter challenged on the eve of prescription, or the limitation period, challenged the will first on the basis of capacity, because her father had been diagnosed with cancer a couple of years before preparing the will, and he was slowly deteriorating. And then secondly, on the basis of undue influence, alleging that her stepmom, who despised her, didn't like her, would have influenced her father. So instead of approaching the case and the facts with the assumption that should always be made, which is that a testator has the total liberty to dispose of his assets however he or she sees fit, the judge analyzed the facts in the case and the evidentiary record through a very particular lens. I will withhold my comments on that lens, but we'll see if it continues to trend in the case law going forward. But it's relevant. I'll read relevant sections of the case, and it highlights it and it says it perfectly, and it's very well written too, even though I don't necessarily agree with the conclusions. So this is the presumption that the judge makes that is not found elsewhere in the law. It is surprising, but certainly not unheard of, to see a father exclude his only child from his will. For such a thing to happen, one would expect to see evidence of major confrontations and blow-ups between the two, or out of the ordinary acts of cruelty or dishonesty on the part of the son or daughter, or some other behavior that would justify, and this is the important part, such a strong renunciation of the normal parent-child bond. So now we see where the judge is coming from. He's clearly going to be looking at the evidence and the evidentiary record, assuming that it is unnatural for a parent to disinherit their child. And through that lens, he looks at everything. There's a section, and I'll get to the best parts. There's a section where the judge is looking at the spouse, the surviving spouse's attitude, and it's entitled "The Spouse's Attitude Towards Her Own Entitlement to Inherit." And this is the surprising part. The judge writes, "There is multiple corroboration for the conclusion that the spouse was a devoted and loving wife. No witness even hinted that she was anything less than fully and unselfishly devoted to his cause, whether professional, personal, or medical. She helped him with his work, even to the point of supporting him in his class presentations, assisted him with his apparently voluminous correspondence, and when the time came, managed every step of his medical treatments down to choosing his doctors. She idolized him, and he was clearly much better off as a result of having her in his life." He's not summarizing what someone testified to. This is the court's actual conclusion. He says, next paragraph, "In light of the important role that she played in the last 2.5 decades of her husband's life, it is quite normal that she would expect to receive a significant portion of her husband's estate after his passing. One witness provides insight into the extent to which she felt this entitlement." And then he goes on to discuss some of the evidence by one particular witness who confirmed that, yes, the wife had in passing said that she would expect to receive the car and she would expect to receive the benefits of the pension after he passed away. So what does the court conclude? "We thus conclude that Milica, the spouse, was ready to attempt to influence her husband with respect to the contents of the will when they did not suit her. As noted, any significant bequest to the daughter would not have suited her. Among other reasons, she likely felt that in light of her devoted services to him, she deserved to inherit essentially his full estate." So here, you have a court that finds as the surviving spouse to have been nothing but an exemplary spouse, totally devoted to her husband, and totally justified in receiving the full benefit of the estate, nevertheless found to have unduly influenced her spouse because the judge is looking at the evidence through that lens. So, it's a cautionary tale. You never know when you go to court what happens. You think that in preparing a will, you're broadcasting to the world what it is that you'd like, but without some of the nuance and explanation, without him having said, well, you know what, my daughter is taken care of already, or you know what, my spouse, the surviving spouse, actually needs this more than my daughter, which you wouldn't put into a will, but you might put in an accessory document. You never know what you're going to get. And this case took years to adjudicate and then appeal, plus experts squandered the estate. It's really an unfortunate story.
Yoni, if I could just jump in and say something, I think one of the points you made, which is very relevant, is that getting a medical assessment that speaks to capacity is one way of dealing with a capacity issue down the road, but it doesn't necessarily mean it's not going to be raised. There may be issues as to what was the lawyer telling the doctor he wanted of him. Did the doctor understand testamentary capacity? The big problem with all of these challenges is that the estate, the executor has to probate the will. They have to prove the will. And they therefore have to go through this whole process in order to probate what the will maker intended to leave behind as their final testamentary wishes. And that costs money. And who pays for that? Well, it's going to be paid for by the estate to begin with. And there may be a cost order that is ultimately made against whoever challenges a will unsuccessfully. But oftentimes, because the courts have discretion, the costs will be paid from the estate generally. And so across the board, everyone will recover their costs from the estate, and that can deplete the estate, squander it in time.
Thank you, Eric. And a very interesting case, Yoni. I agree. And I think it is an important one because it illustrates exactly what our point here is today in this webinar, is that, it's best to do things upfront as well as you can, because if a litigation does occur, number one, it's probably going to take a long time and cost a lot of money. But number two, as with all litigations, the result is going to be uncertain. And in this case you just described, I think that the conclusion the court made and the ultimate order that would have came out of that probably was a bit surprising to the litigants, who all the way along maybe thought that they had a better case than they did. So I think it's just a great example of the problem that, if you end up in litigation, you need to do everything you can to avoid it, because even if you're doing a great job and things are looking like they're going to go your way, on the evidence, anything could happen. And with that, I think we should just say a few general comments about estate planning documents, the ones you normally see, and some common errors that occur in those documents that tend to lead to litigations. So Eric, why don't we start with you?
Sure. Okay. And so to start off with, if there's a lack of compliance with the formalities of making a will, then that would invalidate the will in most jurisdictions. So most jurisdictions will require that a will is made in writing, that it's signed by the will maker before two adult witnesses who are not beneficiaries or gift recipients under the will, and that those witnesses sign the will in the presence of each other and of the will maker. And if any of those are not met, then the will does not get probated, and you go back to either in intestacy, which means no will, or you go back to an earlier will. That's the case in most common law jurisdictions. BC and Manitoba, as I understand it, are the provinces that have exceptions to this rule. BC used to be a strict compliance jurisdiction, but when it created a new act, which is the Wills, Estates and Succession Act, which came into effect earlier the previous decade, it introduced something called Section 58, which followed and tracked the language of some legislation in Manitoba, which allowed for a record, which is defined as anything that is stored or recorded electronically, can be read by a person, and is capable of reproduction in visible form. It can be held and found to be a will, even though it does not comply with the statutory formalities that I've just outlined. And so that would happen if it represents the testamentary intentions of the deceased person, either to make a will or to revoke a prior will or to make a codicil to an existing will. And what the courts in BC and Manitoba have found, and those are both Court of Appeals, they have found that the test that you apply in determining whether or not this record in fact represents a testamentary instrument that should be probated is: one, is the document authentic? Two, does the non-compliant document record a deliberate and fixed final expression of the deceased's testamentary intention? And there's various factors that could weigh into that, such as the presence of the deceased's signature on a document, it being in their handwriting, witness signatures, if the document refers to revoking prior wills or speaks about funeral arrangements, or if there are specific bequests in the document, and it just reads as a will might, or even it has the words last will and testament as its header. So don't be fooled just because somebody has an existing will that was compliant with the formalities. If you live in BC, if you live in Manitoba, if mom or dad left some kind of document lying on their computer or left it in a folder somewhere, you may very well have a document that the court will have to declare is in fact the will. How does that happen? On application. How does an application happen? Before a judge. It has to be on evidence. It costs money. It takes time. There's likely to be a dispute. Again, this is something to avoid. If you're making an estate plan, don't be writing stuff on a piece of paper that could be misinterpreted later down the road. Another mistake people make is using vague or unclear language when they make their wills. That will result in the executor having to apply to court for directions to get clarity from the court and interpretation as to something that may be unclear. BC, once again, maybe a bit of an outlier. It's got some remedial provisions, which allows for errors or misunderstandings or failures to carry out the will maker's intentions to be remedied by the court on application, on evidence shown, on high expense. But again, you can avoid that by not doing a do-it-at-home homemade wills kit, by going to an estate planning solicitor who specializes in making wills, who specializes in setting up these kinds of plans, because a will may not even be the best plan for you. Let's start with that. But even if you then have a will, at least if it's made properly and it doesn't have these errors, the likelihood of there being litigation down the road, costly litigation to prove the will or a subsequent document to explain the will, to interpret the will, is reduced. Other mistakes, and I know that we're running out of time, but big mistake that people often make is they fail to properly identify the name of a beneficiary or an heir. They'll have somebody identified by a name by which they're no longer locatable, or the executor will not be able to locate that person. And that may cause the gift to fail. They might name a charity that has ceased to exist by the time of their death, or that has amalgamated with another charity. And in the case of charities, there is a process to court whereby it's called CPRA, and we had a discussion about it last year. The court can rescue the charitable purpose trust. But again, that takes money. It takes somebody going to court and having that gift declared valid in favor of a charity that can be identified, or that is the successor charity of the charity that the will maker had intended to benefit. And that's not possible, the CPRA concept, with the benefits that are left to your children, for example, or to other beneficiaries that you wanted to have share in your estate. And then the executor or the alternate executor that you name. If you don't name an executor, you just make a will and you don't say who's going to administer your estate, you're getting back to the situation where you don't know who's going to administer your estate. There is a hierarchy. Under that hierarchy, certain persons can apply to the court for a grant of administration, but you don't know who that person is going to be. You don't know whether or not they're up to the challenge. You don't know whether or not you trust this person. I mean, the hierarchy is it goes from the spouse and then goes to the parents and then the children. But the fact of the matter is, you don't know, and there's inevitably going to be a dispute because everyone wants to be the one to administer the estate because they don't trust the other persons, they don't trust the siblings. The easiest way to fix that, to avoid that, name an executor that you trust completely, someone who's not controversial. Name an alternate, name a second alternate, if need be, name a third alternate. So make sure that if you die and your named executor has died before you, there is somebody else to take over the estate administration. Or even if the executor doesn't die, they decline, for example, to take up the role. And then you need to have someone else in place to avoid this challenge to the executor. And by picking someone who's uncontroversial, you also avoid applications for passing over, applications to have the executor removed, which again cost money. The executor will have to defend that and have essentially themselves indemnified for the legal costs from the estate, which you really wanted to leave to your family members, but is now being spent on lawyers and litigation fees. So that's a big issue. Because of time, we can't go into too many cases, but I can just point back to the one that I mentioned earlier on about mom and dad dying without wills in 2005 and 2010, respectively. Inevitably, there was a challenge as to who would be the administrator. It ended up being a trust company, both here and in Hong Kong for the respective estates here and there, but not before hundreds of thousands of dollars had been spent on court applications trying to see who's the best person who's going to be the administrator. So those are some of the common mistakes that we'll see that you can easily avoid by seeing the right people, getting the right advice, and making the right call as to who should administer your estate.
Thank you, Eric. Clearly a lot of potential errors that could occur, so really underscoring the value of visiting a solid estate litigator to help you with your plan. Yoni, I just want to take this point to you, get your take on the common errors you see in estate planning documents that you encounter. And I want to ask you to address Eric's point about when you're selecting the executor or the administrator of the will, and in particular, if you are going to elect to use a professional to take on that role, some general advice you might have for a professional administrator.
Sure. So first of all, I would say that Eric did a great job of completing the message on how important it is to actually consult with a professional to get the appropriate, who will guide you appropriately through this and avoid some of these mistakes, which should be easy to avoid, particularly when it comes to complying with the formal requirements of a will, writing something that isn't vague or incomprehensible, incorrectly naming a beneficiary, etc. Professional doing their job should really steer you clear of those basic mistakes. To the specific question about a professional liquidator or a liquidator who's a third party but happens to be a professional, an accountant or a lawyer who is close to the testator and is a trusted advisor of the testator, and who's then left to administer the estate and dealing with the heirs who are interested in having it liquidated and distributed quickly, and who may, not all get along. The first thing that I would say is make sure everybody's on board with your fees. Make sure that that's not going to be challenged, and everybody understands the scope of your mandate and is on board and signs off on that. Otherwise, you're going to potentially have to confront the heirs or be confronted by the heirs, be taken to court, and when you render your account, have to have your account rendered judicially instead of amicably, which will also cost the estate money at the very end, at the point when all you want to do is make a distribution. So from the outset, make sure everyone's on board with your mandate, make sure your fees are agreed upon, and that should facilitate the task.
Thank you, Yoni. That was a specific question from one of our viewers, so we appreciate that. And Eric, now I just want to go back to you to quickly discuss, this concept of wills variation and where the law is going in BC in that respect, and what our listeners need to know about that.
Sure. And so when I speak about this is for our BC audience, or for people that have assets in BC, because that would be applicable as well. So essentially what wills variation is that at BC's Wills, Estates and Succession Act, there is a section in there which says that on application by either the spouse, which is common law, or married spouse, and common law, they would have had to have been together for 2 years at the date of death, or of the deceased's children, be they adopted or natural children. The court can, if it comes to the conclusion that given the size of the estate and the nature of the relationship, the will maker has made inadequate and unjust and inequitable provision for one of these persons withstanding, the court can take a red pencil to the to the will that you've made and redraft it and redistribute the residue to make gifts as the court deems to be proper in the circumstances. So again, just bear that in mind. Yoni spoke about testamentary autonomy and how important it is within the context of a jurisdiction like Quebec. It's important in BC as well, but not as much. It's not held as sacrosanct, because the court says that even though you have testamentary autonomy, you also have potential legal and moral obligations that you owe to your spouse and to your children. And if you fail to meet those obligations, I, as the judge, am going to rewrite your will. I'm going to make sure that you do what you ought to have done to begin with. And only then am I going to defer to your testamentary autonomy. And so that is something to bear in mind, and why in BC we often recommend that parties don't make a will, or if they do, they have a different estate planning tool in place, like an alter ego trust, or they have a joint spousal trust if they're over the age of 65 and qualify. Because if you don't, then anything that is in your estate is subject to this will's variation. So if you want to disinherit your idiot son, George, because he is going to squander whatever you leave him or her, whatever you leave him, he's going to go to the casino and it's just going to go right down the river. If you disinherit him, the court can say, well, you didn't meet your moral obligation to your child, even if that child is adult, even if that child is independent, and it can give that son something. So you want to bear that in mind. There are ways of protecting yourself. The first and best way, don't have a will. But again, you need to have other plans in place, because if you don't have a will, that's mistake number one. We started off on that basis. But if you don't have a will, there's nothing to vary, right? if you do make a will, you can have a statutory declaration or you can make a memorandum in which you set out the reasons for disinheriting your son, George, and why you're benefiting other persons. And the court will look at that and make an assessment of whether or not those reasons are valid and rational as at the date of death, right? As at the date that the will was made, but did they hold true as at the date of death? And so if you disinherit someone, for example, because you've been estranged for 20 years, but then subsequent to making the will, you reconnect, and at the time of death, you've been in a great relationship for the last 3 years, but you haven't had time as the will maker to make a new will, the court's going to vary that will almost certainly because the estrangement happened in a prior setting. So again, I don't want to go too far down that rabbit hole because it is BC specific, but bear in mind, owning property in BC, your will, even if it's probated in a place like Alberta or Manitoba, would still be subject to variation with respect to real property held in BC under BC law. And if you live in BC and you die in BC, your will is going to get varied unless you have really good, solid reasons for disinheriting a spouse or a child.
Thank you, Eric. A very interesting development in the law, and seems to be occurring in BC under the wills variation legislation. And to Yoni's point in the case he described earlier, in other ways in Quebec, that you may think your estate is properly drawn up and your assets are protected if you have a will, but as we've seen, in these two examples at the very least, that a will alone is often not enough. And if you're relying on a will, litigation could ensue almost certainly.
And always be aware of equity, right? A court of equity will try to do the right thing if it can, and then will try and find its way back through the facts to the situation that is before it. And that really is where this claim comes from. It's an equitable claim. Don't come to court with dirty hands if you're trying to make a claim for will's variation, but know that the court is not going to be too impressed if you, the will maker, disinherited your spouse, for example, who lived with you for 35 years, and you left everything to your side lover or to your children to the exclusion of your spouse. That's not going to fly, and the court's going to vary your will.
Right. And I just want to address some of these quick questions that have been rolling in that I think really relate to this topic. If you want to keep the court and their red pencil out of your estate plan, what about these clauses that you can insert into a will? Some would call them inter rerum clauses, discouraging beneficiaries from going to court to challenge the will. Yoni or Eric, whoever wants to speak to this, do you see these clauses come up a lot? Do they result in litigation, or does something else occur?
Well, let me jump in and say that I would certainly not recommend them. I'm not a planner, but I wouldn't recommend them because I think that in BC, at least, they're not going to stand. So if you're talking about a clause that says if somebody files a claim for will's variation, then they forfeit their right to claim under the estate or whatever is gifted to them, the court's going to set that clause aside or treat it as pro non scripta on the basis that it's against public policy, because the beneficiary has a right at law to make a claim for will's variation. And if you're trying to scare them into not making a claim and then not provide for them adequately, the court's simply going to disregard that clause. So no, I don't think that they're helpful. I certainly think that they're also not going to necessarily be upheld depending on your jurisdiction and what the clause provides. I wouldn't recommend them. It's certainly not an effective way of preventing litigation. There are other far better ways of doing that by having a different plan in place that might not result in a claim for will's variation, for example.
So just if I may jump in for Quebec, the answer is the same, but we get there more simply. The Civil Code has a clear provision which states that such a clause is deemed unwritten in the will. It's not enforceable. You could not make a legacy or a gift conditional upon the beneficiary renouncing their right to contest the validity of a will.
Thank you, Yoni. And if we could go to the next slide. Appreciate it. And I've been sprinkling in the questions as they've come up, and I'm mindful of the time, but just a few more here that I want to address before we call it for the day. Here's a question. What is the best way to handle a beneficiary who is refusing to sign the the release before an inheritance is handed over? Practical question. How would the two of you recommend that one deal with a beneficiary who's not playing ball?
Are you asking me or Yoni?
Let's go with you, Eric.
Okay. Well, first of all, for those who don't know or haven't been the recipient of a gift under a will, when the executor is ready or in a position to make either an interim or a final distribution, they will present you with a release saying that you release them from all liability relating to their administration of the estate up to that point. They will have provided accounts that you can review and see what they've been doing. And the reason that they insist on that is because they want to ensure that once they've distributed the funds out of the estate and are therefore no longer able to rely on estate funds to present to fund a legal defense if you were to come after them, that you've released them, right? And so the question is, how do you deal with a beneficiary who refuses to sign a release? And the answer is very simply, you have one choice and one choice only. You're not allowed to withhold the distribution. You have to pass your accounts before a registrar of the court. And that basically means you're going to go to a court. It's going to be a contested hearing where you present your accounts. The accounts are reviewed by the court. You're going to be challenged on what you did. You're going to provide supporting documentation such as invoices and account statements and checks and whatnot. And you have to go through each and every line item that is challenged, pass your accounts, and then you make the distribution. You are not allowed to withhold the distribution indefinitely or to try and use the release as a sine qua non to making it. You have to go to court. You have to pass your accounts.
Thank you for that, Eric. Yoni, any final comments on that point?
No, the same rule would apply in Quebec. It's either amicably or judicially that you render your account. If you can't succeed at doing so amicably, the court will do it for you. Costs money, waste of time.
And remember that if you're the person challenging the accounts, let's say there are 5 beneficiaries, everyone else has signed the release, everyone else has approved the accounts, and you're challenging them, and there's an account passing and it costs $50,000. Well, guess who the court in all likelihood is going to order to pay from their share of the estate the cost of that account passing, unless you are substantially successful in showing that the executor has mismanaged the estate or spent money that he or she should not have.
And also, one last point. There's no obligation in Quebec to make an interim distribution. So if you're going to be difficult with the liquidator, liquidator is just going to wait until a final distribution is ready and at that point render their account judicially. So up to you if you want to cause the liquidator difficulty for no reason.
Yeah, and then that holds true in BC as well, only in very exceptional circumstances. And I actually was in court on one of those where there was a financial need and there was a lot of money left in the estate after a proposed interim distribution could have taken place. Only in exceptional circumstances will the court order an interim distribution. Ordinarily, the executor or the administrator is entitled to wait until they get final clearance from CRA, and then they'll make the final distribution upon the passing of their accounts or upon receiving releases from the beneficiaries.
Makes sense. And it seems like with respect to a difficult beneficiary, maybe there's not a ton that can be done at the front end to avoid that. And a court application would be necessary in any event. But gentlemen, I want to thank you for your time here with us this morning. I'm mindful that we have blasted by the scheduled 1 p.m. end time. So I just want to take this opportunity to thank everybody for being here with us today, for everybody who submitted questions. Special thanks to you. It makes these presentations a lot more fun to be able to respond to your particular questions as we have our discussion. So upon the conclusion of the presentation, you will all be presented with a link. We encourage you to click on that, provide your feedback, and let us know what you liked, what you didn't like, what we can do better for you in the next presentation. And if anybody posted a question that we didn't get a chance to address or something that was said that you would like some clarification on, don't hesitate to reach out to me or Eric or Yoni at any time. We'd be happy to provide you with further information on that. And I'll remind everybody that if you visit the Fasken Institute section of our website, fasken.com, you'll be able to see all our upcoming events, all our upcoming webinars, including the 3rd installment of the Fasken Estate Litigation webinar series, which is scheduled to occur in December. So Yoni, Eric, thank you for your time today.
Thank you very much.
Thank you, Desmond, and thank you to everyone who joined us. Desmond, thank you for keeping things flowing and for getting us to the finish line, even though we were a little bit over the allotted time.
It was a lot of fun. Looking forward to next year's.
Thank you, everyone.